And now, it's The Law Show on CL650. A comprehensive look at everything you need to know about the law.
Talking about love or law, you decide. It's The Law Show on CL650, and welcome back. I'm Zach Spencer, and joining me in studio today, Alyssa Lockhart, partner at McQuarrieHunterLLP, and Leah Donaldson, associate at Macquarie. And where is Macquarie situated?
We're in downtown Surrey, and we serve the entire Lower Mainland, and we are formerly located in New Westminster, so we have strong connections both north and south of the Fraser.
All right. And Leah, you wear two hats at Macquarie, right?
I do.
We've had you on for family law, and now we're here for talking about wills and estates.
Yeah, so I do family law as well as estate litigation at Macquarie.
And you're just straight estate planning, and not estate planning, but estate law and wills?
I do a blend of corporate work and succession planning, and that leads into the estate planning and estate administration.
Now, succession planning is vital. I mean, a lot of people don't want to think about it, but is it really just preserving assets? Is that a big part of what you help people structure their estate and their planning and their wills?
Right. So succession planning we typically think of with our corporate assets. So who will take over the business, the family enterprise? Who will benefit from the equity that we have built up during our lifetimes? And then when we look at estate planning, we might consider it just conceptually slightly different, where those are our personal assets. So the larger, broader estate plan will include both the corporate and the personal. But when we talk about succession, it's usually corporate.
Okay, so when someone is thinking about their will, and they probably haven't for a while, how often should you rethink, Leah, a will?
You should probably rethink it, first of all, in normal periodic increments. So you can say every few years, but definitely on any major life-changing events. So on the death of someone close to you, on a marriage, a divorce, it's a good idea to come in and talk to someone, a professional, about whether there needs to be any changes made. And
you touched on it. Why speak to a professional? Can't you just do this on your own? What's your advice? I know what you're going to say, but give us an example of how it can go wrong and why you think you need to have a professional.
Okay. I have one that came in last week.
Okay.
So husband and wife drafted their own will. And I do use the term will specifically because they didn't do one for each of them. So they created one document that they purported to be their mutual will. You can't have that. Each of us is an individual. We will each die at a different time and under different circumstances, owning different assets. So first and foremost, you have to have your own will. You might mirror the will of your spouse, but you can't share one. So these people drafted their own, and they drafted it in such a way that their executor was supposed to be the survivor of the two of them. And if the two of them died together, then it was yet another person. Unfortunately for them, they didn't die together. But that was the only provision they made for this other person to become the executor of the last of them to die. They also, in their will, did not include an attestation clause, which means that the witnesses didn't attest to the fact that they had seen these people sign in front of them. So now we have to go and take extra steps. We have to locate the witnesses. This is many years ago. And we now have to locate them in real time and get them to sign an affidavit, a statutory declaration that says they saw this document. Now, it's highly unlikely they're going to recommend or remember that this was the document they saw. We're aware that one of them is likely deceased. Given the age, the other one is also likely deceased. That makes this document a writing, which might be intended to be a last will and testament, but it doesn't meet the pillars of a legal will. And so now we're going to be looking at a new section of the Wills, Estates, Succession Act, which we refer to as WESA, that allows for a rectification of these types of errors. Before WESA came into effect in March of 2014, we could not resolve these issues. It just
what would have
wasn't
happened
a will.
Then? Yeah.
Then
it would not have been a will.
Yeah, it's an intestacy. You've died without a will.
So you're trying to fix after the fact what wasn't done properly. And how successful can you be with that?
We can be quite successful with it under various circumstances. This particular document is very clear. It looks like a will was copied. They threw out the clauses that they thought were extra because, lawyers always use extra words like those attestation clauses. So there are some very important things missing, but it is clearly stated to be a will. It's clearly stated that they understand they're disposing of their assets without further control of them. That's a key that often is missed in self-help wills. But ultimately, the success that we get is not the biggest concern for the families that we work with. It's the cost and the time. And that's where Leah might be better able to give people an example of what the real harm of drafting your own documents can be.
Yeah, so even if the mistake, we'll say, can be fixed by, say, myself or maybe Alyssa, it depends on what lawyer you would have go into court. The reality is that lawyer is having to go into court. That step is necessary when it would not have been necessary had it been drafted properly. And everyone knows legal fees can be expensive. So if you could have avoided that by investing a smaller sum to make sure that the will was drafted properly, I think most people would prefer that over paying for an application.
Well, the argument is I'm long gone. Why do I care? So what is your advice to people? You see what happens after the fact. So well, many things can happen, but what's a sort of a common thread that you see from people who haven't done it correctly and now the generation after is having to deal with it?
Right. So there's a few things. I mean, first of all, instead of spending a few $100 to $1,000 on a document, now you're spending a few $1,000 to $100,000 on litigation. That's a huge difference. But yes, the person is dead and maybe they're not interested in the money. But the gifts that they set out in that document can fail. So when they really feel that this individual should get the sailboat, they've been out on the boat with grandpa every summer for their entire life, maybe that gift to that grandchild fails. And that maybe we do care about. And we want to know that we're not fighting about that.
Yeah, so you want to make sure that your last thoughts on who should get what is actually going to follow through.
Right. If the document fails, the gifts can fail, and that's maybe a worst case scenario. But what happens in the family argument? Because if the document fails and a family says, well, look, it's what he wanted or what she wanted anyway, then the gift doesn't fail and we don't really have that discussion. People just make it right. But really, when we're looking at it, it's because the family is fighting over the asset. So even if you don't care about the sailboat, maybe you still care about the grandchild or your children. And so they're embroiled in a legal fight. And I often tell clients, the first argument your children have after you die is the first one you cannot resolve by simply saying, shush now, leave your sister alone.
Right.
Right? So the fallout from my perspective as a practitioner is family discord.
So even though the will might not have been worded properly and doesn't hold up legally, if the siblings or whoever is named in the will can agree that, well, that was the thought of our parents and or grandparents, and we should sort of abide by that, even though it might not be legal. You don't see those ones, right?
We typically will, we might see them and we might help them move things around. There might be tax consequences. That can happen. But I wouldn't rest on that. I wouldn't rest on knowing my children. And I have 3 girls, and I won't rest on that. What I say to clients is, I haven't met your children. I'm sure you're right about them, but I've met everybody else's kids, and I wouldn't rest on that faith.
And Leah, you're the one that has to go and have a judge decide what's best for the situation.
Yeah.
And that's not always what's best for the person who's passed, right?
Absolutely.
Or their wishes.
And there's never any guarantees in court. So as strongly as some people may feel about an issue, there is never any guarantees. The only guarantee is that it will cost a lot of money. So the planning side of it is to prevent that, the family discord, the legal fees, the uncertainty of it all.
So getting your will or your estate set up properly is one thing, but also power of attorney is something else you need to add while you're living, right?
Right.
And does that cost a lot to do that?
Power of attorney, depending on where you go, it could cost between $200 to $250,
So
maybe $175. It really is not a lot. The downside to not having a power of attorney is that if you become incapacitated and not dead, then you will need somebody to help you in most cases. If you don't have a power of attorney when you become incapacitated, someone who cares about you or who will take over that role will have to apply to the court to become your committee. And on an uncontested committeeship, which means nobody's complaining about you taking on that role, they don't want to do the job instead of you, you're going to expect to have to pay maybe $5,000 to $7,000 in legal and court fees. So when we look at a contested application, we might be in the $60,000, $70,000, $80,000 range for one party who wants to be the committee. We don't know what the other side is getting billed.
Wow.
So when we look at that...
So why would there be a situation where someone would contest it? Why would they want to have the power of attorney say over the surviving...
The committeeship.
Yeah.
Because there's no power of attorney in place. So a committeeship is a competition between people who neither of them have a power of attorney.
But why would somebody want that? Say you didn't do the power of attorney for your wife, and then she's ill, and you're not in charge. Who else would want to do it other than the husband, for example?
So if a party is not married, for instance, we can have siblings, so a daughter and a son. So mom becomes incapacitated, and daughter, who thinks she would be better at managing the money, says, I should be the committee. And for lots of reasons, as you can imagine, anyone that has a sibling can imagine, there's reasons why they don't think that their sibling should be acting. I mean, it's a lot of control. It's a lot of responsibility that people are getting with these. It's basically control over their finances. So we see contested committeeships all the time. It basically, the person hasn't chosen someone. The court gets to decide for them.
Is there a common thread that wherever there's money, there's conflict? Is that pretty typical in family situations?
I don't want to make us sound that cynical.
What have you seen, though? I mean, you must have seen all kinds of situations.
We see all kinds of situations, even when there isn't a lot of money involved. I think it really actually is more dependent on the personalities of the people.
It can really boil down to control.
All right. When we come back, we're going to pick up on the power of attorney. Maybe we'll walk through exactly what that is again and different scenarios for why you would want things set up a certain way or how things have gone bad and your time practicing wills and estate law. We have Alyssa Lockhart from Macquarie Hunter here and Leah Donaldson. We'll continue our conversation next on The Law Show.
There's more of the show still ahead. This is The Law Show on CL 650.